Hey guys, it's Sam from Legal Livewire. Just wanted to show you guys this new, different editing style that I'm trying to introduce into my channel, I guess I'll call it. If you guys don't like it, just say so and I won't do it anymore. But I'm going to kind of take a poll on this one. And I'm going to try to figure out a way to do a poll in the community to where you guys can vote like, yeah, we like this, or no, we just want it straight, cut, and dry. But I really just am truly interested more and more and more in the intricacies of law and what is happening in our justice system today. And so I just wanted to start talking more about truth and accountability and what's going on in our justice system today. I'm finding I'm having a little bit more time on my hands, and it's a lot of fun doing this. So I don't know, join me today with this new video editing style and tell me how you like it. If you hate it, just tell me you hate it. Just leave a comment below that you hate it, and we'll just go from there. Today on Legal Livewire, we're diving into a case filled with twists, legal arguments, and an intense back and forth between defense and prosecution. At the heart of it all, accusations of resisting arrest, assault, and obstruction. Let's break down the details. The defendant faces multiple third-degree felonies. When asked how he pleads, his responses waver. Not guilty, guilty, then back to not guilty. Its clear tension is high, and clarity is lacking. In a surprising moment, the defendant appears to be in his car while attending the hearing. The judge, clearly unimpressed, insists he clarify if he's currently driving or just parked.
Mr. Icon, if you're driving, you better pull over right now. Mr. Burkett, we can recall your case when your client's not driving.
Certainly, Your Honor.
I'm not driving.
You're currently not driving, or you weren't driving? Choose your words wisely.
I put in my drive. I was pulling in my driveway.
Okay, Mr. Burkett?
Her report never mentions any type of assault that ever took place in this case. Never said that she was ever assaulted by this person. And as this court is well aware, an assault requires the offer, the threat to harm. He never did that. He never did any of the requirements that requires an assault. And the prosecutor never even argues that. Yeah. The officer claims while searching for him that she stepped into a pothole and injured herself. Well, we asked him if that is the case, then we need to see some documentation.
The defense argues that there's no evidence of assault, only that the officer sustained an injury unrelated to any alleged actions by the defendant. According to Michigan law, he insists, there must be an explicit threat or harmful action for it to be considered an assault.
Questions of fact are the providence of the jury, while questions of law are reserved for the court. Since the parties are not come to a consensus as to the facts, I'm not inserting myself. Neither one of you have waived a bench, so this has to go in front of a jury. And it's up to the jury to determine the questions of fact.
The judge remains impartial but firm, suggesting the defense's interpretation of assault might not be as clear-cut as they claim. The case is moving forward, with the judge placing the responsibility of determining facts on the jury.
Judge, just for the record, we had sent Mr. Burkett notice of the entirety of the body camera right around the beginning of December. I included an excerpt from that because it was too big to email to the court, showing the 15 seconds or so that is directly at issue. There's 7 different ways you can violate the statute, and clearly the defendant did at least 3 of them by opposing, battering, resisting, obstructing, endangering a police officer. If the court wants to, if the court wants to find that there wasn't an actual assault, certainly, the way that the defendant said, "You're not arresting me," or something to that effect, and I'm paraphrasing, and threw his arms up, it's resisting.
The prosecution paints a picture of a hostile defendant who resisted law enforcement, suggesting his actions, even if unintentional, created a dangerous situation for the officer.
And Your Honor, and the most important thing about this whole incident is this: that in our paragraph, we stated that The officer at no point ever told my client that he was under arrest. They pulled him out the car, they searched him, they wanted to put handcuffs on him. He broke and ran. Now, the prosecution's position is, well, he should have known he was under arrest. No, Your Honor, there you're flirting with due process. He has an absolute right to know that he's been under arrest, or he kept asking, why are you putting handcuffs on me? She wouldn't tell him. She wouldn't tell him he's under arrest. At that point, he broke and ran. And we said that's not obstructive. And the case that I cited to you, Your Honor, is a case that's directly on point. So, yes, People versus Moran, which was, I think I quoted in my brief to you, Your Honor, 491 Michigan 13. It's cited by the Michigan Supreme Court. Case almost identical to this. The police tried to arrest this person. They went to his house, and he said, well, I'm not going to let you in. Slammed the door on them, and they was injured. And the police went back and said, we sent somebody downtown to get a search warrant to come in your house. And he said, well, you don't have it now, and slammed the door on them again. They said, well, that's obstruction of justice, obstruction. It went all the way to the Supreme Court, and the Supreme Court says, no, that's not obstruction of justice. That's an illegal arrest. You had no business doing that. Same thing here. They had no business stopping this man, putting handcuffs on him, and not telling him that he was under arrest or why he was under arrest. And our position is that doing all of that, they violated all of his rights, and that this court should either dismiss or quash the information.
The defense leans heavily on due process, arguing that the lack of clear communication from the officer justified the defendant's actions. They present case law that seems to support their position.
It's up to the jury to determine the questions of fact. That's under People v. Kohenek, 491 Mich. 382 and 411, a 2012 case, and People v. Lennon, which is 456 Mich. 625 at 637 in 1998 case. The defendant's motion is going to be denied. It sounds like there are some discovery issues that need to be attended to. Mr. Burkett, if they are not resolved, you should file a motion regarding a discovery demand. Hopefully you two can just work that out. At this point, would you like another pretrial hearing, or are we setting this up to trial?
Probably a pretrial to see if we can. She's out.
How much time would you like, Mr. Burkett?
I'm sorry, I didn't hear you.
How much time would you like?
Couple of weeks anyway. I'm trying to look at my calendar now, Your Honor.
The 12th or the 26th? Those are our options.
The 26th of
February.
that would be fine, Your Honor.
Okay, 26th of February it is, Mr. Isom, sir. We will see you back then.
I'll prepare an order, Judge.
Gentlemen, thank you. Have a good day.
The judge denies the motion to dismiss, emphasizing that the facts are for a jury to determine. She schedules the trial date, leaving the defense to prepare for an uphill battle. This case raises questions about due process and the limits of law enforcement. Stay tuned for more updates on stories like this, where we like to explore the depths of these types of cases and not just play the regular dockets, but really look into what is going on in our legal system today. Hey, thanks for watching, and don't forget to subscribe for more stories about truth and accountability in the justice system.